Hello everyone, welcome back to AP Government. So in this lesson we will cover the last part of the First Amendment. We will actually cover the freedom of speech and expression. So the First Amendment, just to review, states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for redress of grievances. Now, in the First Amendment, it makes it clear the rights that we have in speech and expression, stating that Congress shall make no law abridging the freedom of speech or of the press. Even though the First Amendment provides the freedom of speech, it always wasn't that way. In the Sedition Act of 1798, as I stated in our first couple of lectures, it had actually restricted speech that negatively reflected on the Federalists who were in power. Under the Civil War, the Lincoln administration took some harsh action against those that sought to undermine the Union's case to abolish slavery. The freedom of speech is the cornerstone of individual rights, facilitating the more effective realization of such freedoms as the right to vote and to participate in the democratic process. So the real question is, why is there such a high regard to the freedom of speech? So a couple of theories are that the marketplace of ideas came from Supreme Court Justice Oliver Wendell Holmes in 1919 as a metaphor of the premise that the best test of truth is the free exchange of ideas. So the four theories are marketplace of ideas, self-governance, self-fulfillment, and a safety valve. So for the very first case that covers the First Amendment, we have Schenck v. United States, dating back in 1919, and this Supreme Court case established the clear and present danger test. So just a few facts on the case. In 1917, when the United States was starting for active participation in World War I, Charles Schenck, pictured here, a general secretary of the American Socialist Party, was tried and convicted of distributing leaflets arguing that the military draft was immoral. Now, the pamphlet posed little danger of interfering with the draft, and the Supreme Court refused to release Schenck from jail. He was charged with being in violation of the Espionage Act of 1917. So what was the legal issue? Well, the legal issue raised at the Supreme Court was whether the defendant's acts came near enough to accomplish this substantive offense to be punishable. So the clear and present danger test states, the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that the United States Congress has a right to prevent. It is a question of proximity and degree. When a nation is at war, many things that might be said in time of peace are such a hindrance to its efforts that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. This is specifically coming from Supreme Court Justice Oliver Wendell Holmes. Now, the ruling was that the clear and present danger test and the majority opinion from Supreme Court Justice Wendell Holmes, as I just said earlier, and then after this case, there were other Supreme Court cases that used the clear and present danger test as well. A good example is Dennis v. United States of 1951. And it states that the Supreme Court ruled that the First Amendment does not require that the government must wait until push is about to be executed. The plans that have been laid and the signal is awaited before it interrupts seditious plots. This gave a measure of credibility to the Red Scare and communism. In this case, Chief Justice Learned Hand stated, in each case, courts must ask whether the gravity of the evil discounted by its improbability justifies such invasion of free speech as is necessary to avoid the danger. We adopt this statement of the rule. As articulated by Chief Judge Hand, it is as stringent and inclusive as any other we might devise at this time. It takes into consideration those factors which we deem relevant and relates their significances. More we cannot expect from words. So then there is this play on the Warren Court's preferred freedoms doctrine, and I will point in Justice Earl Warren is pictured here. He was a pioneer in the Warren Court, and his court is probably one of the most famous courts in Supreme Court history, only because of the cases that he actually ruled over, like Brown v. Board of Education, which we will get to a little bit later in this class. But he's very significant in the Supreme Court history. So let's see where Warren viewed the clear and present danger test. So a good example is in Brandenburg v. Ohio in 1969. And the Supreme Court ruled that the government cannot punish inflammatory speech unless that speech is directed to inciting or producing imminent lawless action, and it likely to incite or produce such action. Now, let me go back here. So in this case, the Supreme Court withdrew from the old clear and present danger test and replaced it with a test that was more protective of free speech. This case started the imminent danger test, which is speech directed to inciting or producing imminent lawless action. Advocacy is likely to produce such action. So that's what the imminent danger test is. And there's those two things that constitute that imminent danger. The speech must be directed to inciting or producing imminent lawless action. So it must produce some type of a lawless action, maybe violence. And advocacy likely to produce such action. So even the action or the advocacy that's being taken place, there has to be like 1 in a million chance that some form of action, whether it be through legislation or a law, that it might not produce that. So in alternative, the Warren Court came out with the preferred freedoms doctrine, which basically offers protection to those exercising their rights of free expression in other contexts, including to writers, publishers, filmmakers, and protesters. It also provided the foundational additional protection in modern activities as information has decimated to the internet. So the next one is the freedom of the press, libel laws, and prior restraint. So you will be able to see this in the next few Supreme Court cases that I'm going to go over. So let's go to the first one. And that is New York Times v. Sullivan of 1964. Now, the Supreme Court ruled that people must prove that the newspapers have published false facts with malice, bad intentions, or reckless disregard for the truth. and they ignored clear evidence of contrary facts. So in this case, the people have to prove that the newspapers kind of preemptively printed material that they knew was false, but they printed it out anyway, and they have to prove that it was in fact false. So the burden switches to the one that is being, the one that's doing the suing, and they have to prove that the person that they are suing, that, a newspaper, a magazine, a media person in the media or in the news, that they recklessly disregarded the true facts, and just printed or said the content of what they're trying to publish. Now, obviously, this case dealt with the issue of libel, and libel is the crime of printing or disseminating false facts that harm someone. After the ruling of Sullivan, libel was also applied to public figures as well as public officials. So now a libel lawsuit brought by any famous person, whether it's the President of the United States, they must prove that the newspaper or magazine in question not only printed false facts, did so, but also either with malicious intent or in reckless disregard for the truth. So what is prior restraint? So prior restraint imposes a limit on publication before the material has actually been published. So it's kind of like a last minute editor. So a famous case, the Pentagon Papers case of 1971. Obviously, this has to do with Watergate. The Supreme Court refused the U.S. government's request to stop the Washington Post and the New York Times from publishing a classified study of the U.S. decision making about the Vietnam War. So, obviously, when you go to these Pentagon Papers, obviously it had something to do with Watergate, and it had a lot of confidential content in regards to the Vietnam War. So, as you can tell in these little these newspaper articles, the front page, you have the Washington Post and New York Times into how both of these cases panned out. And if now you just look at the headlines, just look at some of these sublines. For the Washington Post, it says voted 18 ratified into law, moved by Ohio, enacts 26th Amendment. So we got there's a lot of governmental things, a lot of constitutional things going on at this time, especially with Nixon. And then, of course, the decision allows printing of stories on Vietnam study, war file articles resumed, and then New York Times, it says Pentagon Papers charges are dismissed. Judge Barn frees Ellsberg and Russo assails improper government conduct. So this is a lot of really cool things, and I highly recommend that you kind of look through those articles, and they're super cool to kind of go back in time at the time during the Watergate scandal and this publication of the Pentagon Papers, and how all three branches of the government played a key role into not just the Pentagon Papers case, but also Watergate as well. But unfortunately, going back to where we are now, it says, unfortunately, getting prior restraint is very difficult for the government to actually accomplish. So this is it's very difficult for the government to prove or to prevent this from, for this to take place. So that's why you rarely see it, because it's just so difficult for it to happen. So the next one is symbolic speech in flag burning controversy. So what is symbolic speech? Well, symbolic speech is the non-spoken forms of speech that might be protected by the First Amendment, such as flag burning, wearing armbands at school to protest a war, or camping out in public parks to protest the plight of the homeless. So the real question that comes into mind that we must answer when it comes to symbolic speech is, are such forms of symbolic speech protected by the First Amendment? Well, we can try to answer this question by some Supreme Court cases, and the Supreme Court actually tried to answer this question through United States v. O'Brien in 1968, and the Supreme Court ruled by refusing to allow a Vietnam War protester to burn his draft card in violation of federal law. So it was a federal law that you cannot burn your draft card. In actuality, it was kind of your you are tearing up federal property, and it is, it's a federal mandate that when you are asked to come into the draft by the federal government, that you show up. That's the expectation of that. So obviously, for every Supreme Court case, there always has to be some type of a test. So the symbolic speech O'Brien test. So here are some of the things that a symbolic speech Supreme Court case has to meet. So number 1, the government interest must be valid and important. Number 2, the interest must be unrelated to the suppression of free speech. And number 3, the restriction should be no greater than is essential to the furtherance of that interest. So this case really introduced the 3 criteria for determining whether the regulation of symbolic peace may be justified. So a symbolic speech Supreme Court case, they must meet all 3 of these elements to prove that symbolic speech under the First Amendment was violated. So in Texas v. Johnson in 1989, the Supreme Court ruled by invalidating the prohibitions of desecrating the American flag enforces in 48 of the 50 states. Justice Brennan stated in his opinion that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. So the government just can't willy-nilly prohibit an expression of an idea only because society might find that idea offensive. So the government cannot always veer to public opinion. It must be within the bounds of the Constitution. It must be within the bounds and be within the confines of the First Amendment. Now, if it's outside of the confines of the First Amendment, obviously that's a different thing. But just because the public is in an uproar and they're kind of sad and upset, the government just can't just say, oh, the people are so upset, we really got to make this right. We got to, kind of squeeze this and try to twist and turn to make this issue fit outside of the First Amendment, and the government simply just can't do that. And if they do that, obviously that's an abuse of power. You're violating the First Amendment rights of that particular individual, freely expressing their ideas. So obviously there is good speech, and then obviously there's some hate speech. So there's this thing called hate speech codes. And basically, in the 1970s, communities have sought to prevent speakers preaching hatred for certain groups, including racial, religious, or some other classification, from exercising their rights of free speech in certain specified neighborhoods or other places where the perceived harms may be great. And then in 1977, the courts refused to deny Nazis the right to march in a parade in Skokie, Illinois, home to a large number of Holocaust victims. So what they wanted to do was they wanted to take these hate speech codes or codes, civil codes, where where you have a high population of a, in this case in 1977, a high Holocaust victim population. What they wanted to do is they denied the Nazis their right to march because of the demographics. So that's what their goal was, is to prevent hate speech from taking place, because that does exist. So, where do we draw the line? Is there a line between hate speech and just blatant freedom of speech? And is hate speech protected under the First Amendment? I mean, these are questions that we can simply ask to ourselves as Americans, as we continually read the Constitution and understand the Constitution as a living, breathing document. So this concludes our lesson on the First Amendment. So we are done with the First Amendment. So we will go on to the Second Amendment. We'll get into a little bit of the Third, the Fourth, the Fifth, and all the way up to the 10th Amendment through the Bill of Rights. And then we will dig a little bit deeper into other amendments, as the course winds on. And then after we get past the 10th Amendment, we will get into Article 1, 2, and 3 of the Constitution. So please be prepared for that. So if you have any questions, let me know. And I hope you have a wonderful day. Bye.